Yes, late. Work. Unfortunately, I needed snacks. I haven't really put anything in my mouth since the start of the day, so I really hope I didn't just keep that bus from pulling over here. Turn, damn it, turn. Yep, they turned. Okay, that's fine. Now, why did my car cam kick out? There we go. All right, we are good. Hopefully we have audio, in which case I don't really care because none of you are going to be able to hear me anyway. I don't know who the hell damaged the Barocco like this, like assholes. Anyway, we are back on Recross. Hanky was making a spanky of himself, and I gather that I'm going to absolutely lose my shit with this afternoon. I've seen various things on X throughout the day, and I'd say people are pretty accurate on that. But let's get into it, get on the road, and I'll shove my stuff my face.
Well, do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm softer than the hybrid, yes?
Yes.
When you push it, you can push in. Much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash...
The fuck do you want, Brennan? For them to use real humans in the crash tests? Seriously.
Crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm. Would you agree?
That wasn't what he was testing.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf?
I don't have enough hands now.
And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones are you use for test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you use Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever? Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No, because there are none.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you had never done before and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experiences whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion. Putting aside Dr. Welcher or Dr. Rentschler, you have responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes, and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Okay. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the taillight cover?
What the fuck? What the fuck? Objection means stop talking, fucktard. Oh, I'm just going to quickly get this out before Bev actually calls me up for a sidebar because, you know, what? You know what? It doesn't matter who's objecting. I just want to get this out because once the bell's rung, it can't be unrung. Yeah, I gather today's pretty bad, Stephanie. And truth be told, I want to get through this Barocca first, but I'm starting to think I'm not going to get the opportunity to. What's annoying is that I am driving and holding the Barocca in the other hand, so I can't use my remote, which means we're stuck here during the sidebar until I can drink this because it has a ridiculous opening. This was a really freaking bad idea, Hayden. And I'm not even comfortable drinking it using my left hand, which is ironic. But anyway, how was your day, chat? Or night, I should say. Hayden will be stressing the profanity filters. What fucking profanity filters? It's only you guys that have the profanity filter, and even then I don't have to stress about it. Oh, halfway there. It's a long sidebar. Fuck. Right, you know what? I'm gonna have to risk it. I'm gonna put the drink down.
Pushes forward and pushes on.
Too far.
The arm reaches.
At some point. Correct. And so while glass with the taillight.
Holy shit, how far did I jump ahead? Yay, and Seymour? Sweet. I got family up Seymour way. Alright, so who won, who lost?
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there? Correct. And so while glass
it's true, it was a stupid
plastic that
question.
shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
No. You can see
Well,
it from
the
the
arm,
footage.
as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree
No.
with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the
What the
taillights
fuck?
shatter, right? Wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
No.
Sorry, can you repeat the question?
Yes. Would you agree?
My God, this is not Wile E. Coyote. It was a full frontal impact that caused the arm to be flung out of the way. No, the arm is not going to get dragged for 50 feet down the road. Like, at this point, I've got to think that Wolf's sitting there going, this guy can't have seriously asked me what I think he's asking me. Like,
That if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm.
no, it would not.
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
So what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reaches a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged? Yeah, I don't know if I understand.
Drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
You said it moved the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower?
No, Spanky. The taillight is not going to shatter and then dig into his arm because the crash test dummy wasn't tethered. What the
And the vehicle pushes and drags against the arm.
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand. Before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
That's what you're saying is more reasonable than him being
generally, I guess
bitten by
again,
a
it would
dog?
move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of the taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so do you like to agree with me? You could disagree with me. Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
Okay, the Brocker is done. Hopefully I'll be able to stay awake for the trip.
When you were showing those photographs today regarding test F, now,
Okay, firstly, I'll just say it's an honor to be considered as someone that you would also watch alongside EDB. But I had no idea she was on a delay. That's interesting.
you use Randy in test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Oh my fucking God.
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I mean, you're a dummy too.
Randy. He's not a crash
How about we
test
put you
dummy,
behind the
is
Lexus?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
he? So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
Motherfucker, your guy painted his arm blue and leant into it. Are you really actually going to concern yourself with whether or not what they did was scientific or not? You're a fucking hypocrite.
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did your test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. so that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet. You used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those timeframes, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet. You used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that.
Yes.
And the street has hard concrete and has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
In the photos that you were shown today on redirect examination, did the defense show them to you during the direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before?
Oh, damn it, I
Zoom in.
completely forgot my red solid cups.
Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please?
Sorry, I know it was uncouth for me to talk while eating. My
Can you
apologies.
tell from here?
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No, it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
I can only assume as much because Hank Brennan wasn't available on that day. He's about the only useless dummy that I can think of that I'd be willing to put behind a Lexus at this point.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
If you ever do get the chance to come to Australia or New Zealand, Nobby's Jerky. Go and jerky Nobby's.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Beyond the scope, Mr. Brennan.
Fuck me.
A few more questions, Dr. Wolf.
Sorry, that sheep
You
blended in
showed
with the
us
grass. I didn't
holes
see it till the last second.
in Randy's sweatshirt from Test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
What,
Sorry, can
like
you
the
repeat
neck
the
hole?
question?
When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the.
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there's any holes in the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here. You see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground. And
Wait, what holes? What holes are on the back?
had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just one more.
Okay, is this something that I need to pull over for? Because I feel like I'm missing the full gravitas of this because I can't see the screen. Like, I was following the line of questioning there, but now I'm sitting here trying to think, what the fuck did I just miss because I'm brain fogged? All right, you have my attention.
You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked, give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
He actually went there.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So Sustained is to form.
This is just foundational, Your Honor.
Sustained is to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3-arm, were you going faster than 24 miles an hour?
Yes.
And
Yeah,
what was the
no-
calculation again on the increased force that would be exerted on the taillight, on the arm, or the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
I'll allow it.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long? Gotcha.
So the objection sustained.
Asked and answered. Fair enough. I get the point you're going for.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were?
So the objection's sustained. He said he doesn't know the sizes. That's the end of that.
I realize he said he doesn't know. He was
That's
asked
What?
the
questions.
end of that, Mr. Jackson.
What?
You have the, Mr. Wolk, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Sustained. And jurors disregard that.
Did you ever
What?
see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
Bev, shut the fuck up.
You were asked a question about
That's a material
the arm
misrepresentation.
being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
In your testing, how long did it take the hybrid 3-arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again. About
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, right?
The objection sustained and it's
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no pulls, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
All right, I have follow-up questions.
okay. Go ahead.
What? Why was she trying so hard to keep them from saying, hey, by the way, those shards are absolutely tiny. They're inside a tin about this big. Oh, yeah, I'm pulled over. I don't have to worry about...
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct. Yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with
Brennan,
this?
it's not
If you
going to
have an
cause
arm that's
damage
actually
to. It's
struck
not
at
going to cause
25 miles per
it's
hour,
gonna cause
you're going to have
abrasion.
significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, the source.
No,
Dr. Rentschler, do you agree with that?
Objection.
so I'm
What the
going to allow it. I'm striking source.
Do you agree with that?
I'm sorry. Can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
No, because the arm's going to move out of the way.
In reference to the greater damage, we talk about damage to the arm.
Do you agree with that phrase?
No.
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with
I'm
that?
going to allow it.
What the? It's fucking straightforward physics. If I hit and the thing moving behind me is pushing me out of the way, it's not going to like sit there and dig in. It's not going to cause the cracked tail light at the moment of cracking is not going to cause what we see on John's arm. It's just not.
I'm going to read this one more time, okay?
Okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
No.
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
No,
Well,
not correct.
If it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move
No.
with the arm.
It's going to move and pivot.
Thank you.
All right, so Jerry's, we're going to take our morning recess. We'll see you in about 20 minutes.
Please rise for the jury. Bring this way.
All right, so I'm told council wanted to see me.
Your Honor, issues has arisen related to the cross-examination, recross-examination of the last witness, and Mr. Alessi would like to just put in detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue. I'm asking Mr. Leslie to address the board.
Okay. What do you want to tell me, Mr. Leslie?
Bear with me a moment, Your Honor. I need to put on evidence gloves.
Okay. Not gonna lie, probably could have done that at the table, but all right.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. In what I'd like to do, Your Honor, this regard.
Ooh. And he's mad. I mean, I can already see how this is going to pan out, but
The hoodie. In this regards, questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits. And then I am going to use exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves. And it will become quite obvious very shortly what the issues are.
All right. So what are the things that you want to have marked?
What I would like to have marked. Well, what I would like to have marked, the first document, and I want to get the specific title. These 2 documents are from the criminalist file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
May I see that, please? Okay.
That is the back of the hoodie, Your Honor. If
God, I
I
hate
could
that woman.
please have the next mark in order, exhibit for identification.
Exhibit ZZZ, Friday identification.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back from my office?
Busted.
Okay.
Thank you, Your Honor. Thank you, Madam Court.
Oh, excuse me.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is what happened was Attorney Brennan held up the casing with the hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
So I realized that line
Okay.
of question was going to be asked, and Mr. Brennan will be casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Leslie.
So here is the back
Okay.
of the hoodie.
Okay. All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get back to this in a moment. But I would like to do it and certainly entertain any of your other questions, but in a logical order.
Sure. So I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
You're in the no, Bev. Are you fucking kidding me? You're in the middle of a motion for a mistrial for professional misconduct, and your biggest problem right now is whether or not the jurors are going to be back in time for lunch. Are you fucking insane, woman? The level of unprofessionalism.
All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29th, 2022.
So do you have something you said when
Shut
you
the
said
fuck up,
obviously
Bev.
cut by the criminalist? Do you have something that shows that chart that I couldn't understand quickly? Is it on that? Is
Yes,
that to
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right. So is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184, analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your
I
Honor.
just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the variations.
She's acting like she's humoring one of her children.
Let me just get a check on this, Your Honor. I'm not.
Right. Mr. Brennan, you should go over and look at this.
Thank you. And I'm
So Mr. Leslie's statement.
yes.
All right, so this is why. I didn't see where this said.
Oh, fuck, I gotta go on the road.
Mr. Leslie says exterior front.
Can I get the check?
Label cuts.
Pardon me?
The label cuts.
Right, but if I can, Your Honor, I want to clarify this. Yes, I do. Well, let me just make sure I get.
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, yes, it may print the wrong page. I can do it, Mr. Wolf, you print the back, and Your Honor, are you comfortable using the computer or the back? Because I think we just had the wrong one.
We need to mark it though.
I understood. We will, he's printing it right now.
I'd have preferred to have stayed pulled over, but I'm still an hour and 15 away from home, so.
We wanted to have the front and the
Sorry,
back
hour 25.
show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct. But maybe, Your Honor, I'm advised it will take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor.
Shut the fuck up with the sign.
So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminal.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Oh, shocking. You're going to give the Commonwealth the courtesy that they didn't give you.
Thank you, Mr. Court reporter. Sure. Here's another document, chain of custody document. Well, Mr. Brennan is reviewing that. We may head to Madam Court Reporter, the chain of custody document for these, and ask that he marked as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter again and vote up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Leslie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, Your Honor, thank you.
I still do not have ZZZ. All right. Thank you. Okay, go ahead, Mr. Leslie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right. So let's move along from
right,
that.
That's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalist as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Read, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Read's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear, the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Read's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Read to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right. Thank you. Mr. Brennan.
No. You don't just gloss over that with, all right, so now let's hear from the other kid. This is insanity. They buried evidence. He deliberately mischaracterized evidence to the jury. What? I wasn't listening. Oh, I just realized it's probably the part that's going to piss me off, isn't it?
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Oh, fuck off!
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently, but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And
that is entirely sufficient. This is a bell that has been rung. It cannot be unrung. You have deliberately instilled in the jury, in their minds, that there was likely holes on the back of the hoodie from John landing on his back and moving some distance. You have lied to the jury in the middle of a trial. Whether you did that deliberately or not should be a mistrial.
the court should allow the defense to introduce the lab paperwork.
All right.
Oh, wait, what? Excuse
So-
me? The defense should be allowed to introduce the lab paperwork? You mean the evidentiary documents that should have been allowed into evidence anyway?
I'm not going to allow the mistrial motion, Mr. Leslie.
I'm
What I'm
sure.
going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B, 4 of each letters. I'm going to put all these into evidence.
Okay.
They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Leslie, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates?
Your Honor, on about May 18th, when the defense filed a motion to test. So that's the appropriate date.
So May 18th?
Yes, that's
Okay,
good. And that's 2023.
all right. That's what I'm going to do. Is there anything further you want me to include in the instruction?
Funny how they were so quick to jump to putting sanctions on the defense when they fucked up. All she's going to do is give the jury talking to and say, oh yeah, he made a mistake. You need to make sure that you don't take this into account because this was done by this person. Are you fucking kidding me?
Instruction. Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go anymore.
Your rights are saved in regards to the mistrial. I cannot fucking wait to read this appellate brief. Because I'm sorry, the fix is already in there, people. At this point in time, I am now 100% convinced. I'm starting to think that Bev might even give a directed verdict in favor of the prosecution. That's a joke. I'm well aware of the circumstances around that. That was a joke. Don't need people thinking that I'm a fucking retard like Hank Brennan.
More into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up because that's what
Okay.
happened.
Yes. 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 Yes.
Thank you. So that's number one as part of the stipulation, and then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation,
Stop
but just as Your Honor said.
fucking sighing, you cow! It's a fucking mistrial application. I don't care if you've dismissed it at this point. You have to stop with the fucking sighing. It is so goddamn inappropriate. I don't care if at this point you've got a reduced lung capacity or whatever else. Move away from the fucking mic, you bitch. And she's not giving it as a stipulation. It's just going to be an outright instruction. You have to ignore this. That's in no way going to draw the jury's attention directly to it, is it?
With regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, 20. So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
What the fuck?
It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Leslie. I'm not showing disrespect to the court.
Okay.
Of course, we're listening.
All right. So it's what I said, Mr. Lessie. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms.
2025?
Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist of.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf
Fuck you.
about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheathing. It might need to be remarked. The plastic sheathing was marked, but if we're going to put it into a bag or something like that, it might need to have it marked. But we don't need to do that right this second.
May I approach Mr. McDermott with the
Yes.
Thank you.
All right.
No,
thank you.
Bob, I'll be
I'm
perfectly
sorry.
honest. At no point was I expecting her to mention misconduct by the prosecution, because that would tarnish the prosecution, and they get a certain amount of leeway in relation to that. It's bullshit, but it happens. But there fucking well should have been sanctions for that. This is bullshit.
Mr. Lessie, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
Thank you.
So this is exhibit 223.
In your honor, I would hold it as your honor begins to read. Is that consistent with your honor's explanation?
No, I want you to hold it up with the back.
Would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
All right, so Mr. Lessie, why don't you where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer. Return.
Yes,
Thank
court officer.
Bear with me a moment, Your Honor. I'm going to put on the
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here. She's not next. I'm going to call up.
For just the measurements?
Go ahead.
Your Honor, if I could be able to show the exhibits from Ms. Hartnett or the class, along with the next time we're starting to show the class for me by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are, so.
Oh, at this point, I'm like 80% convinced this
Please be
was,
seated.
this
Court is in
was
session.
even if it wasn't,
Right.
it is more than sufficient for sanctions.
Jurors, I appreciate your patience. Mr. Lessie, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know you're...
I'm sorry, what? That's it? What the fuck? That's not even close to what was stipulated. That's not even close to what was agreed. That's not even close to what you wrote down. Are you serious right now? didn't even mention that she didn't even say this is what was shown during the questioning. These are the holes that you cannot conclude were caused by the accident. What the fuck? Okay. No, this is no, just no. No, not okay. I'm done with this bullshit. I'm really, really done with this bullshit. The prosecution openly lies in the middle of the trial. She sweeps it under the rug and does nothing about it. Where the fuck are your grave concerns now, Bev? Oh my god, and this woman's going to continue failing upwards as well. This is absolutely reprehensible. This is not okay. I cannot believe that is all she said about it.
Lunches are here, but I think Mr. Yannetti, your next witness, please.
John Keenan.
Okay, step up, take the part, raise your right hand.
You solemnly swear the evidence given to the court and jury in the case now is the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon.
I'll be honest, that's straying into interlocutory appeal territory for me too. Like, it would piss everybody the fuck off right at this moment, but god damn if I wouldn't be appealing. I don't know if they can file an application to have her recuse herself at this point. I really don't. There's a good chance that the Superior Court turns around and says, no, you're already most of the way through the trial. Just wait, lose the case, and then do your appeal.
Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a
Okay.
little bit about
Guys
your
took the photos of
education
Fairview?
and work history. You're from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School,
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University,
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school,
Where?
Suffolk,
What year did you graduate from Suffolk Law School?
2013.
And what
Did
did
it
you
take
do
7
after
years?
graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker,
And what type of law did you practice?
mostly real estate law,
When did you start Forum Investigations?
in April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right, and it was not the Albert family, correct?
It was not.
Did that individual give you
They sold
permission
the
to
house.
enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, so can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolf, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what
Have a good
exhibit
night.
number is that, Mr. Wolf? 46. Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down.
More doors, more whores!
May I approach the witness, Your Honor?
Yes.
It's gonna look really bad for me if people don't get that reference.
So I put a photograph in front of you. Do you can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the 2 car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
The funny thing is, I genuinely thought I was going to have so much more of a visceral reaction when everyone was telling me I was going to lose my shit. But I think at this point, not only am I just that internally raging at the unprofessionalism and what I feel like is the destruction of my own profession, that I'm at a loss for words. Yes, Bev can eat a dick. Although she probably wouldn't. Probably never has. Seriously? Most of...
Okay, Mr. Wolf, whenever you're ready, if you can display that portion.
Hello, Rita.
You see what has been.
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
Sorry, what?
All right, so we'll fix that during the luncheon break, Ms. Gianetti, to what I said. All right, so can we get Dr. Laposada in here? We'll do a very brief voir dire of her.
At this point, I genuinely believe that Bev thinks she's untouchable. The amount of clear and evident bias is just it's mind blowing at this point.
And you're gonna step up, face the clerk, and raise your right hand. Repeat.
Do solemnly swear the evidence you're in case the evidence, the truth, the whole truth, and nothing but the truth.
I do.
Oops,
All right,
sorry.
Good afternoon.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
I'm also willing to bet that Bev never frames another trial again.
Your Honor, for purposes of expediting, does the court wish me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Laposada's resume to point to exactly where that is, okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Laposada. That's spelled Laposata.
Dr. Laposada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Laposada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that to the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Bev, get away from the fucking
Do you have
mic
a
already.
significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by medical?
I feel like I need to roll up a newspaper and smack her on the nose with it. I mean, she's got a bit of a dog face anyway.
Examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. do it as briefly as you can, with being as succinct as you can.
Certainly, to determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a second about a specific area of interest. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? And I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist can say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school?
At the medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
Pretty qualified to me.
Taught course in pattern recognition.
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
That wasn't a great answer.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you, in fact, testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was injured, well, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it
Is
is.
it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regards to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described to the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Good afternoon, Dr. LaPosada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks, and it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education
fair
classes
answer.
reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound?
No shit.
recognition
There was a
dog
tail
bites?
light on the ground.
It's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Labasada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there anywhere you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had to guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this
Oh
was
my
in
God,
Boston?
he's totally Randall. Just growing up.
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
They're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
Brennan, I don't know about you, okay? Because I don't know what the specific rules are for you in terms of CLE, continuing legal education. But I'll just put it out there, I'd be curious to know exactly what your specification is as to when you last did a CLE on, say, civil procedure. You're a lawyer, you know how to do it. We have to do CLE, we have to do continuing education. Tell me the last time you attended a seminar, and when was the last time you brushed up on specific skills. Honestly, this is such bullshit. She's an ME. She's got years of experience. But because it's been 3 years since the last time she testified about a dog bite, he's going to try and get her disqualified.
I'll ask you about accident reconstruction experience. And I mean this respectfully. You don't have a biomechanical or a medical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces of
God, they don't have to do CLE?
the body, I look at blood stain patterns,
Wow.
I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your...
Oh, apparently, Grifter, they don't have to do any there. But, for example, I have to do at least 1 hour of ethics CLE every year.
report mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes,
I have my list here. Should I read
that's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in the case Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you're the qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Lapasada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lapasada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions? All right. You are all set and asked you to step down, Dr. Lapasada. We'll get to you sometime this afternoon.
Okay, thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Easily. Yes. Your Honor, I'll make this very brief.
Okay.
Dr. Lapasada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog? Was it another animal? Was it another source? Was it lacerations versus abrasions, things of that nature? She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites. She's seen dog wounds. She engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now, than somebody with Dr. Lapasada's qualifications. I will submit on the voir dire that we just completed.
All right. Thank you. Mr. Brennan.
I do not think that Dr. Lapasada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Lapasada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There's nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
Briefly respond.
Okay.
She was, Mr. Brennan suggests that, well, she's only been qualified in one court, federal court, but the federal judge that was handling that case qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing for Dr. LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. LaPosada brings much, much, much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. LaPosada she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites. And I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right. Thank you. All right. I'll get your ruling as soon as I can. So we're going to stop back up at 20 past 2, and I expect to go straight through the rest of the act.
All right, for the court, please.
You know what the annoying thing is? The really annoying thing is that occasionally I try to throw Hank a bone and say, okay, he's just doing his job. But you know, after all the shit that happened earlier today, I don't have it in me to give him that. I wonder if she's timed how long it takes her to get up to her chambers, get the robe off, and pour herself a mimosa. I presume that's why she knows exactly how much time she needs for lunch and that sort of thing. No, it very much doesn't translate well as a prosecutor, and the trouble is that I kind of feel like he'd be a half-decent defense attorney. Because, you know, sometimes if something happens and you need someone to defend you, you need the slimiest person you can find. Unfortunately. The trouble is that defense attorneys and prosecutors have to have very different skill sets. And the way he's handling himself, I don't think it's appropriate. No, I know he's a defense attorney. That's why I think it's so stupid. Yeah, I suppose it could be looked at that he's defending the Commonwealth. I mean, he's certainly defending the accusers of Karen Read, that's for sure. But because he's going down that path of trying to... I think that's a great way to look at it, actually. He's defending the Commonwealth's position instead of trying to prove that Karen actually did it. I tell you what, it does make me wonder who owed Morrissey a favour, or who he asked a favour from to get Brennan in as a special prosecutor. Yeah, Bob, this isn't about justice for John at this point. This is a win at any cost. Can't tell if the batteries are going in my light or not. Oh, I saw a picture of Bev and Morrissey side by side today, and I posted it on X, and I said, the more I look at these pair, I swear they're related, and it's just that Morrissey enjoys his cheeseburgers more. Come on, I ain't got all day. Oh, the DA election's coming up, isn't it? Completely forgot about that. One of these days I'm actually going to give that camera the finger as I go under it. Wait, what happened to Jude?
We could all.
Oops, too far.
Close back the session, may be seated.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. Lapasada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Lapasada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. Lapasada's report on pages.
So let it be known that you have to have peer-reviewed journal articles to be able to be qualified as an expert in Bev's court. Oh, wait! Hang on!
It's 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now, moving on to the testimony regarding not being consistent with a motor vehicle strike, I find...
Wait. Jude, did you have a stroke? Who had a stroke? Wait, what? What?
And that Dr. Laposada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all, in some regards significantly, like I said this morning. So on page 17, that
Jesus
first sentence
Christ.
is in.
I hope
The
you're
second
okay.
sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in the next sentence. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Laposada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
Sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now.
Well, now you don't.
All right. So you likely not get to that day. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them
Oh,
in.
fuck
And-
off. She's got to stop.
Right.
with
We're going to do that now. So
They're
that'll
there
give you an
for a
opportunity to pull your thoughts together.
Right, and I expect what I would do is my attention. I will go through her statement. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any photos, but I may be able to actually go through the court's ruling. It's very specific, and I want to be as
Okay. So let
that as possible.
me know what you intend to put in. All right. And there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs
I
tomorrow.
just want to let the court know, not waste the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. The jury, you can tell just by looking at this jury, they're fed up. So,
Yeah, no shit. They're fed up with Hank's bullshit and yours.
John, the only thing I want to put on record is, with regards to the court's ruling, I do want the record to reflect, that is obviously, it's over the defense objection.
sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Laposada. They have a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the review for identification.
I just need to know when I can make it.
You just made it.
I made it ish. I wasn't-
Okay. Okay.
The point is,
Go ahead, real quick.
the Commonwealth has not explained the delay.
So,
Making this motion. They haven't, and we're playing by the same rules, Judge.
so the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure, but they were objecting. They've had since March to object. They lose the motion in limited time, and then they come in just before
All right.
Just before Dr. Laposada testifies, and now we're sort of sandbagging this and getting the court moves against us. So I want to make sure that the record
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during the proffering of testimony. There's no foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So bring them in, please.
President Jury.
This woman is a joke. Not even a funny joke.
Court is in session. Please be seated.
Jurors, you have been
I reserve this categorization for very, very few people, and the ladies in chat will understand why. I'm officially going to label her as Thrush, because she's an irritating...
extraordinarily patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready? All right, Mr. Tedman, whenever you're ready, sir.
Thank you.
Thank you, Ron. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before. There it is. Maybe zoom in on that a little. Okay.
I don't mind pausing because we've got like 5, maybe 7 minutes left in the stream. So it's clear that I'm either going to have to cover over part of this tomorrow on the way to work, or I'll have to do a stream later on tonight. Given how little sleep I've had over the last few days, I'm leaning towards tomorrow. But to answer your question, Mufasa, if the defense were to just go off on Bev, she just removed them from the case. More than that, there's a good chance they get held in contempt, fined, potentially put behind bars for a day or 2. But just saying, there's situations where it's worth it.
What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left
To
of
the
this
left.
photo, particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes,
And that is a westerly direction toward the house, sir?
correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
You measure from the
How did
belly
you
button
measure?
to the tip of the
I
nose.
used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
I think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen.
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from the where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door, you took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is.
I'll go through until this
So
guy.
are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road,
Okay, if we could have the connecting street where the, that's it.
Fairview Road,
All right, and finally, the one down the bottom?
Chapman Street.
Okay, we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
It would be facing west.
If I may have a moment to...
Okay.
I'll be honest. Judges like Bev are very few and far between, generally because they know that it causes issues for the prosecution when this sort of shit happens. But I will say, this trial is an extreme example
Thank you.
of why trials need to be recorded and streamed. I can only imagine the sort of
Good
shit that we're
afternoon, sir.
missing.
Good afternoon.
You had a wheel to measure,
Correct.
and so there's like a tape measure, and when you wheel it out, it gives a straight line.
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door,
To the main front door to the far left, yes.
and that was about 63 feet.
I believe it was 65 feet, something like that. I have
65?
my notes. Yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side.
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet.
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Is it one way?
Correct.
And back is another 78 feet.
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurements. I'm not sure.
Do you have it in a report that you
I
could look
don't.
at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that. Yes.
Right. What was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway to any of those doors? Did you ever measure it that way?
I did.
And what was the distance you were going to start at the flagpole, walk up the street, up the driveway, down the walk?
Well, I mean, I haven't confirmed it myself, but I'm well aware that people have been floating around that she has a 50% overturn rate on appeal. We personally went through all of her robing room reviews, and we know that she's full of shit. I can only speak for one judge, because there is one judge on X, retired judge, I should say, who has been extremely critical of Bev and the calls that she's made and the way that she has had no basis or foundation for half of her rulings. That's the same judge that I'm really hoping that I can do an interview with.
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. From the measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
I could do better than that. I'm pretty sure I did it as a video. Hang
All
on.
right, you are all set, sir. Thank you very much. Okay, Mr. Jackson.
Thank you, Your Honor. We would ask for
All right, that's the natural point for me to stop that, because otherwise I'm just going to have to... So just give me 1 sec. Oh, I could have sworn I did it as a separate video. Hang on. Content, videos. Sorry, I know you're looking at my shoulder. I shall sort that out in a minute. Oh, there it is. Shareable link. Sorry, I was just leaning over, so it just looked blurred. All right, where are we? I'm going to post the link to the video that I did where we looked at her reviews on the robing room. A good number of them I skipped over because they were just related to this case, and people, you know, kind of like as Dr. Spiegel from Amber Heard's case got that poor bastard, the one that wasn't actually in the trial, the other Dr. Spiegel got review bombed. People were doing the same thing. There are a number of legitimate lawyer reviews on there that are very concerning. I did do it as a stream, but I also cut it down to an individual video. I'm going to post a link for the video. I'm not sure what I think of this actual setup here, but anyway. All right, folks, I'm going to head home. From the looks of it, I probably will cover the rest of this over in the morning, which means we might be an hour or so. But eventually, I'll sort things out and get back to up to date. But as always, please remember. Oh wait, what am I doing? Hit that like button and double check whether or not you subscribe, people. At some point, I'm going to do a video detailing the actual line where I go up one, down one for the subscribers, and how it's been a block over the last 2 years, so I can actually show everybody. But I'm eager to get over the 30,630 mark again. Sounds so ridiculous when I say it like that. But yes, hit that like button. Please remember, you're not a piece of shit. You have value and do contribute to society here, and I will catch you all on the flip side. Cheers, peeps. Oh, what am I doing? I haven't played the outro.
And again, on your way out, please do me the favor of hit the like and subscribe button if you're so inclined. It costs nothing. It's absolutely free, and we'll be friends forever. Bye now.
Unfortunately, some members of the media use their platforms to push their own personal bias, and agenda to control exactly what people think. This is extremely dangerous to our democracy.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.